Joining us right now is Senior Advocate in the Supreme Court and former Attorney General for India, Mr. Mukul Rohatgi. Mr. Rohatgi, thank you so much for joining us. First of all, your opinion on what the Supreme Court has done. It's being hailed as historic.
I think the Supreme Court has taken a very bold step. You see, this controversy of the validity of a pre-independence law has been raised time and again. The last time when the Supreme Court upheld the law was about 60 years ago in Kedar Singh's case. In the recent past, this law, if I may say so, has been used and repeatedly abused by various police and other agencies spread over different states in the country. Please understand that this is an old colonial law which was brought in by a British imperialistic regime when India was not independent. The idea was to suppress the natives who should not collect together to form a group to undertake a violent revolution to kind of overthrow the government by violent means, to keep the natives in place and the fear of God be instilled on them. This was the background of this law. So again and again this question arose, but in the last 10 years, this question has become very relevant because of a rampant misuse. Now, when this question has now arisen, and I wonder that you see, this law has been there for more than 100 years, and in the last 75 years of independence, I have rarely come across an important case or a substantial case where sedition has been proved. I mean, the center's affidavit in the Supreme Court talks about 6 cases from Assam. I don't know what has been the result of those cases finally, whether appeals are pending. But more than 300 cases or 500 cases have been filed against various persons, including some, political leaders and MPs, etc., where sedition is readily invoked. It's a very, very serious offense. It's a very serious offense, can be punished with death, and it is being used, in a very light manner without understanding what
So, Mr. Rohatgi, how would you respond to the government? And, this seems to be some sort of a flip-flop that the government has been doing in the Supreme Court. First saying that, we think that the law is fine, to then saying that we think we should place this law under review. Then when the Supreme Court said that should we keep the cases in abeyance, they say no, they should not be kept in abeyance. Do you think that the government has to be clear?
See, let me tell you, traditionally, every government always generally supports a law which has been made, whether this or any other law. Take Article 3, Section 377. Now that was also supported. In fact, I was the lawyer after I debated office. I started that case in the Supreme Court challenging Section 377. But this is the first time, and I say that the government's stand is welcome. It is wholesome that the government reported that the Prime Minister has said that it is necessary to have a relook. That shows that the government is not being cussed about it, that we will oppose anything, which comes against the government. I welcome the government stand. It is equally bold. The court stance is equally bold, that the law is suspect and therefore stop the operation of this law till you come back after a review at your own end. I mean, I would welcome both the steps with equal wholeheartedness, the government stand and the stand of the court.
Okay, but Mr. Rohatgi, my final question, you also saw the stand of the government, the law minister, who says that we must respect the Lakshman Rekha. Now the big question is that who's violating that Lakshman Rekha all this while? When you look at poor conviction and you look at a record number of cases where arrests are made under this law, one really wonders who's crossing that Lakshman Rekha. Is the court wrong in deciding what it did today? What Lakshman Rekha do you think the Supreme Court crossed?
I don't think the court crossed any Lakshman Rekha. Courts have and judgments are there where courts have stayed or suspended the operation of laws, we on much lesser grounds. On the ground also that a law cannot be made by a state legislature, can only be made by a center, or can only be made by a state, cannot be made by a center, or you have crossed the parliament has crossed its bounds in making a law. There are many laws which have been stayed. I mean, it's nothing new. It has happened in the past. This matter is very, very serious. And when the other side, namely the government itself, is saying, and I submit very, very appropriately, you should not blame the government at all. They have been frank enough to say that we'll have a relook. Now, if you are going to have a relook, it is obvious that in your own mind it is also suspect. If that is so, stop it, because, you know, it results in deprivation of liberty. Now, liberty is, in our constitution, is the highest pedestal. So something which deprives somebody of liberty, and if that is suspect in the minds of both sides, that is the court, the petitioners and the government, obviously you will keep it in abeyance for 2-3 months, let people get bails, etc., subject to strict conditions, and the government come back. I mean, I don't think anybody can accuse the court of crossing any Lakshman Rekha whatsoever.